Everybody ready?
Yes, sir.
If we said no, we would have. I'm gonna get me good signs since the guy is dead. No. I think he did gold sticks in bed. He's got it. Yeah, I remember.
Everyone remain seated, please. Come to order.
Mr. Robinson? Your Honor, I spoke to General Moore. Dr. Lippman is at lunch. If it would be okay to finish with Ms. Tilley and then perhaps take up any issues with Dr. Lippman.
Okay, that's fine. All right. We'll bring him in.
Get in there, witness back, Your Honor.
Did you get your computer straight?
Yes, Your Honor, it is. Hopefully it will continue to be that way.
Okay, that's fine.
Sorry, do we want to go ahead and put this up on the screen and make sure it's out? Unless she needs to pull it up, it's not on my screen.
All rise.
All right, please be seated. How was lunch today? Good. Good to hear. All right, we have everything working, looks like. Joan Norman, go right ahead.
Thank you, Your Honor. Officer Tilley, you had just been testifying about the white and green towel hanging on the hooks here.
Yes.
And clicking on this triangle over here on the wall over the dresser, could you describe what is shown in this view?
This is another Panascan. The position of the camera has just changed, and you can also see the closets with the towels we addressed, and further in at the trash area there were more towels.
And there is a blue box over the trash area. I'm going to click on that. Could you describe what is shown here?
This is a towel that I have marked with the number 1. There's also a red and white towel that was under this towel.
And this is actually a still photo that's embedded in the third scan. Is that correct?
Yes.
Your Honor, I am going to, for the record, just mark that as previously entered Exhibit 20F.
20F. Oh, I see. The photograph.
Yes, Your Honor. And Officer Tilley, could you describe what's shown in the next image? I just clicked on the blue box that said 2 green towel.
This is another still photo of the towel, just another angle, and you can better see the red and white towel that was underneath it.
For the record, that is Exhibit 20G. I have 2 items. If we can give that one to Officer Tilley first, and then maybe go ahead and let the defense look at that one. That's the green towel.
Has that been previously entered?
No.
Green one is not.
And Officer Tilley, you're being handed an item. If you can take a look at it and let me know if you recognize it.
I do.
And what is that?
This is, this bag contains the light green towel that I had noted was near the front door, and that's the same towel that is in the photo. And it also contains the date and time collected, as well as the address and complaint number and type of case it was.
Your Honor, I would ask that this item be entered as the next exhibit, which I believe is 23. And if we can go ahead and hand Officer Tilley that item, and I'm going to ask you about that in 1 second. If we can go back to the screen. And I have clicked on the triangle that said 2 green towel again. Could you describe what is shown in this image?
This is another photo, just a different angle over the top of the trash area that I marked one that has the light green towel, and you can see the red and white striped towel underneath it.
And so this is the still photo that was previously entered as 20H. And Officer Tilley, do you recognize the item that you were handed?
I do.
And what is that?
This is the bag that contains the red and white towel that was from near the front door, and I've also included the date and time collected, as well as the case number, type of case, and address.
And I would ask that that be entered as the next numbered exhibit, which I believe is 24. Officer Tilley, when you are processing this area of the crime scene, could you describe what, if anything, you observed, if you did anything specific to the green and red and white towel that was on what I believe you described as trash?
Yes, I also evaluated these towels with an alternate light source.
And what is an alternate light source?
It is, how to explain it, like a black light. It will illuminate or help fluoresce possible bodily fluids. It just isn't a wavelength of light that we can't see outside the visible range.
And do you remember anything specific about these towels in that area of the crime scene?
In this area, the towels, the green towel, it did fluoresce. It had an apparent stain on the edge. And the red and white towel also, it smelled of urine, and it had a brownish colored stains on the towel.
And we have gone back to the third scan, and I'm going to kind of just pan across the room. And what, if anything, did you process in this area of the room?
In this area of the room, I also I photographed the drawer, the interior of the drawer that's highlighted in blue, and also photographed the bed that's there and marked it, the bedding.
And I have clicked on the blue square that says to dresser. Could you describe what is shown in this image?
In this photo, you can see multiple dressers as well as the lower bunk with bedding and just trash and various items in the room.
And this is previously entered photograph 20I. Officer Tilley, I'm clicking on what says to top drawer. Could you describe what is now shown in this image?
This is a photo of the drawer opened and its contents. And in this case, I was focusing on the box of condoms and the condom in the box in the drawer.
And Your Honor, this is previously entered photograph 20J. And Officer Tilley, there is a blue link to close-up of items. I've clicked on that. Could you describe what is now shown?
And that is an additional close-up showing, focusing on the box of condoms and condom in the drawer.
And this is previously entered photograph 20K. Officer Tilley, you've described kind of your part in processing this scene. Did you process the entire scene by yourself, or did others assist you?
I was assisted.
And who were you assisted by?
Felicia Evans and Sergeant Nicholson.
Okay. I don't have any other questions. Thank you very much.
All right, cross-examination.
Good afternoon, Ms. Tilley.
Good afternoon.
The job of a tech, crime scene tech at that time was to locate, collect, preserve, and process any evidence, right?
Yes, that's correct.
Okay. And how, and preserving evidence is extremely important, is it not?
Yes.
Okay. Because if it's not preserved, it could spoil or elapse or disintegrate, in other words, go away, right?
Yes, there's that potential.
Good. And when your unit goes to a scene, as you did at room 213, the best way to secure a room, or excuse me, to secure the room is to prevent anyone from going in and out, right?
That would be ideal, yes.
Okay. And that's to keep someone from potentially contaminating the room, right?
Yes, that would assist in that.
And the best evidence is to take pictures of, in this case, the room before anyone were to enter, right?
That is ideal, yes.
And that would be before someone could accidentally kick something over or move something, which would mean that the room was not in the condition you originally found it, right?
Yes.
We don't know whether anything was removed from room 213 prior to you arriving, do we?
Not that I recall.
Okay. And you can only document what, if anything, was removed after you arrived, right?
Yes, I can only document the scene during my time there.
Do your notes reflect that anything was removed from room 213 while you were there?
That was removed while I was there?
Yes, or removed after you finished.
At the time of my investigation, I did assist at collecting items. However, some may have been taken later, just during additional part of the investigation that I'm not aware of.
Okay, so to the extent of your knowledge, we know that there were, I believe, 2 light green towels a red and white towel, and a white towel, correct?
I did collect those, yes.
Okay. And did you collect anything else that day?
I believe that was the extent of what I personally collected, but my coworker did also collect some items.
Okay.
Yes.
And do you feel that the ID department did a complete and accurate investigation in room 213?
I do.
Okay. And is there anything that you or your group missed that you know of?
Not that I know of.
Okay. Now, I believe, did you run a fluorescent bulb in the room?
I did run a crime scene lamp and an alternative light source in the room. Yes.
Like sourcing the room. Okay. And you ran the crime scene lamp over the floor, did you not?
I did.
And nothing was found, right?
We did not. I did not observe anything of value that fluoresced.
Okay. And exactly what you were looking for is some type of something with evidentiary fluorescent value, right? Or fluoresced value?
Yes, that's correct.
Okay. And you found nothing of evidentiary fluorescent value on the floor?
I did not.
And you found nothing of evidentiary fluorescent value on the lower bunk, right?
That's correct.
And you did not scan the top bunk?
I did not.
And how long would it have taken you to scan the top bunk in room 213?
Maybe 5-10 minutes.
Okay. And were you specifically told not to fluoresce the top bunk?
I was advised that it was not part of the scene to investigate.
Okay. And I believe with the fluorescent lamp, you're looking for bodily fluids, is that right?
That's correct.
And that would include blood, right?
Yes.
Seminal fluid, right?
Yes.
And vaginal fluid, correct?
Yes.
Now, you did collect items. Did you collect items from the bottom bunk yourself?
I did not personally.
Okay. And the only item with that showed possible bodily fluid was the light green towel on top of the red and white towel, correct?
That is the only item that I observed that fluoresced.
Now, the size of the room is, would you say 12 by 12?
I would say that would be approximately. I didn't get an exact measurement.
Okay, all right. Now, when you process items and preserve items, we talked about that's really important, is it not?
Yes.
Okay. And you indicated that you smelled urine on the red and white towel, correct?
Yes.
Okay. I smelled the red and white towel.
Objection, Your Honor. Counsel.
Okay. I'll rephrase. I'll rephrase. If there was a smell on that towel, it was your job to preserve that smell, right?
At that time, I had documented in my notes what I smelled at the scene.
Okay. But did you do everything you could to preserve the smell on that towel?
I bagged the towel to ensure that it wasn't contaminated with any other items at the scene.
Okay. You didn't put it in a sealed bag, did you?
I put it in a paper bag and I sealed it with tape.
Okay. Let me ask you this again. You didn't put the red and white towel in a sealed bag, did you? Look, do you know what a sealed bag is?
I didn't put it in a vacuum sealed bag.
Okay.
Also, if it could potentially destroy other evidence in a vacuum sealed bag if it was still damp by any chance, it could cause mold or other bacteria to grow.
Okay. But I noticed today the brown bag has a hole in it in the bottom right-hand corner. Did you observe that?
I did.
Okay. And whose job is it to preserve the evidence once it's out of your control?
At that point, I deliver the evidence that I've collected to our property section for storage, and then it could be sampled and processed further from there.
So do we know how the hole in the bottom of the bag got in
Your
there?
Honor, the question clearly is asking for speculation.
Your Honor, I asked her, does she know? That's not speculation. If she knows, she can answer. If she doesn't know, she doesn't know.
Well, rephrase your question.
Okay.
Let me just say, did you put the hole in the bag?
I did not.
Do you know who did?
No.
One second, Your Honor.
Sure.
Okay. That's all I have, Your Honor.
Redirect.
No redirect.
All right, thank you. Officer Shirley, excuse. Who's your next witness? Ms. Evans?
Yes, Your Honor.
I think she's pretty brief. Go ahead, calm down.
Take the clerk and raise your right hand.
You swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Could you please state your name for the record?
My name is Felicia Evans.
Where are you employed?
I'm currently employed as a forensic scientist, firearms examiner in the Firearm and Tool Mark Identification Unit within the Metro PD Crime Lab. Prior to my employment in the crime lab, I worked as a crime scene investigator with the department's crime scene unit for 10 years.
And did you respond to 1900 South Drive, the Gillette Hall, specifically dorm room 213 with Officer Tilley on June, I believe it was 27th of 2013?
Yes, ma'am, I did.
And could you kind of explain what was going on when you arrived that day?
I was called in by my sergeant, John Nicholson, to come and assist Investigator Tilley with the execution of a search on a dorm room that was said to have been the scene of an alleged sexual assault.
And when you arrived that day, what was going on?
When I arrived, I spoke with Detective Mayo, who briefed me as to what was known at the time. CSI Tilly had been inside processing the room approximately an hour prior to my arrival. I went through, walked the scene with her. She pointed out what had been done, items of interest that she had photographed, and then from there we went on to process the scene together.
Was there anything unusual about that scene as related to kind of other crime scenes?
It was a little unusual in that it was a search warrant or a consent to search on something that had happened several days after the original incident.
And is that typically something that you respond to or do?
No, it's typically not.
And once you arrived at the scene, what were your duties? Could you describe what, if any, processing that you performed on the scene that day?
As I said earlier, CSI Tilly had already begun processing and photographing the scene initially. I walked through with her, and it was decided that I would assist in processing the area for latent prints, searching for possible evidence. We used an alternate light source to look for the presence of any bodily fluids within the room, specifically semen. And then we also searched bedding and collected various items of evidence.
And could you describe the areas that the alternative light source was used on in the room?
We used it on the room in its entirety, just going around looking at the floors, the walls, the furniture, the bedding. We found some towels that were crumpled up and also hanging near the closet. There were 2 closets in the room, and there were two towels hanging on hooks near the closets, and those were searched also.
And were there any areas in the room that gave any indication of fluid or anything with the alternative light source?
I believe we had a positive visual reaction on one of the towels near the edge of the towel, and that was collected as evidence.
And when you say a positive effect, is that sometimes called fluorescing?
Yes, so when seminal fluid or body fluids are exposed to an alternate light, they can fluoresce.
And could you describe that area of the towels where the green, I believe that you said the green towel, that it fluoresced. Which one are you referring to?
I believe it was the green towel located when you walked in the front door of the dormitory room. There was a green towel and a white and red striped towel laying kind of in a garbage pile.
And do you remember anything specific about that area of the crime scene?
When I walked into the room, initially I was overtaken with the smell of urine, and the crime scene itself was very dirty, just riddled with trash, food bags, drink cans, water bottles, clothing, shoes were cluttered. The area where the towels were, it was basically just a mound of trash.
And what, if anything else, did you do to process that scene?
After the alternate light search, we then processed for latent prints on the floor, on various items of furniture. We found a condom box inside of a drawer in one of the desk drawers that was processed, as well as a separate condom outside of the box. We also swabbed various areas on the floor that did not fluoresce or indicate any type of bodily fluid. With the visual search and the alternate light, we went ahead and swabbed that area for any potential trace evidence.
And that area of the floor that you said you swabbed, do you remember anything specific about that area of the floor?
That was the one area in the room that looked tidier or cleaner than the other areas in the room. It appeared as though trash or whatever items that had been there before had just kind of been moved back, and there was a clear space on the floor.
Your Honor, at this time I would ask that this witness be passed Exhibit 20J, which is a photograph, a second to last photograph. If we can place that on the overhead. Or we
Is
can,
it still tied to your computer? No.
it shouldn't. Your Honor, we can also just pass the witness the photograph, and I think she can hold it up. The jury very recently saw it.
Okay.
Officer Evans, can you take a look at the photograph that you were just handed?
See?
Do you recognize that photograph?
I do. This is a photograph of the desk drawer. It's ajar, and it's showing the contents, including a condom box and a unwrapped condom.
And if you don't mind holding that up for the jury, or if maybe we want to pass it through just so that they understand what we're referring to. And could you describe what it is exactly that you did to the condom box?
Yes, ma'am. The condom box was collected for the presence of latent prints, or processed for the presence of latent prints using a black powder method.
And what, if anything else, did you process for latent prints?
We processed the furniture in the room. We processed the walls, the floors, the door, the interior and the exterior to the room itself, and the doorknob.
And are there certain factors that play into whether or not you would process any items for prints?
Yes, the texture of the item, first and foremost, is of concern when you're processing for prints. Certain items and the texture of those items will hold a print better than others, or actually leave a print better than others, as well as you're looking for items that pertain to what you're there for to begin with. And we were investigating an alleged sexual assault, and so we were looking for areas within the room that may have come into play during that, and items that may have come into play during that.
And I believe that you're about to be handed an item. Can you take a look at that and let me know if you recognize it?
Yes, I do.
And what is that?
This is a latent print jacket or envelope that we use to store the latent print evidence that's collected at scenes.
And could you generally describe what a latent print is?
Sure. So if you look at your hands, you'll notice all of the ridges and the detail that's present, the pattern on your palms and your fingers. You can leave a latent print. Latent just means invisible to the naked eye. When you come into contact with something or touch something, the oils and the residues from your hand can be left on that object that you've come into contact with, and they're left in the pattern that you see on your hands. So in order for us to visualize those, typically you have to use some type of enhancement method. In this case, we did the black powder method, where that's applied with a brush over the surface. The powder will then adhere to those oils and those residues that are left behind in that print, and then it visualizes the latent print and allows us to then collect that using just basically a tape method that's applied over the area. The print then adheres to that tape, and then we will affix that to cardstock or white paper to get a nice contrast between the black fingerprint and the white paper.
And after that's done, do you do anything else with those prints?
No, we just basically label where we got them from, document where it came from, what they were off of, the day and the time it was collected, and then the print cards themselves are sealed in an envelope such as this and then turned over to our latent print examiners.
And could you describe what is contained in that latent print card?
Inside the envelope are two latent cards that I filled out with the information of the object that was processed. And this one is the door, this one is the condom box. On the back of the card are the prints themselves that were lifted. There's another piece of paper in here that is from the examiner.
And so there's actually 3 pieces of paper within that one envelope?
Yes, ma'am.
And you referenced that one of them references the door.
Correct.
How many latents were you able to lift from that area?
Off of the door, on the interior side only, I lifted 2.
Your Honor, I would ask that that be made the next exhibit with, if we can have, I guess, 25, with A being the latent print card from the door, B being the latent print card from the condom box, and C being the additional, which I think she might need to retain B and C just so I can ask 2 more questions. Yes. The lift card from the condom box. Could you describe what you were able to obtain from that?
Yes, ma'am. I've obtained 2 prints from the condom box. One from the front side of it and one from the rear side.
And were you able to obtain anything else, or was it just those 2 prints?
It was just those 2 prints.
I don't have any other questions about that item. That can be submitted into evidence. And if I can just have one moment.
All right.
No more questions. Thank you so much.
All right, Cross.
Hello.
You stated on the record that when you arrived, Detective Mayo and Ms. Tilley were already at the scene?
Yes, ma'am.
Okay. And when responding to an alleged assault, what items do you consider relevant for evidence purposes?
I mean, that would depend on the type of scene. In this particular scene, we were dealing with a college dormitory, so based on information that we were given, we knew that certain areas were pertinent, such as the floor, the furniture around the floor, and possibly there were 2 bunk beds, the lower bunk.
Okay. So you processed this scene for prints, is that correct?
Yes, ma'am, that's correct.
Okay. And you processed the walls for prints?
Yes, ma'am.
The furniture?
Yes, ma'am.
The doors?
Correct.
Doorknobs?
Yes, ma'am.
And the floors, is that correct?
That's correct.
Okay. And no prints from Mr. Batey were found on the doorknob, is that correct?
To my knowledge, no, they were not.
And no prints from Mr. Batey's were found on the door either, is that correct?
To my knowledge, no.
No prints of Mr. Batey's were found on the condom box as well, is that correct?
To my knowledge, that's correct.
In fact, the only prints you found on the condom box were Mr. McKenzie's and Mr. Banks?
I believe that is correct, yes.
Okay. Did you also collect items for DNA testing?
We collected items for potential DNA testing, yes,
Okay.
ma'am.
And what items did you specifically collect?
I specifically collected bedding. I collected the sheets and the comforter from the lower bed. I collected the swabs that were taken, the floor area. There were 18 total we kind of quarantined it off and labeled 9 areas that were of interest to us and swabbed those areas. So those swabs were turned in for potential DNA or bodily fluid evidence. We also noticed a reddish brown crusty material on a tub that was housed underneath like a reciprocating fan, and it looked to be a throw up or a vomit like, so we took a sample of that and turned that in as well.
Okay. And you also testified on direct that you used a light source to look at the walls and the floors and the bedding and some furniture, is that correct?
Yes, ma'am.
And that you basically used it on the entire room, pretty much?
Yes, ma'am.
Except for the top bunk, is that correct?
We did not search the top bunk, no.
Okay. So you did the walls, the floors, the furniture, and bedding, except for the top bunk, right?
Yes, we were told to disregard the top bunk.
Okay. You said that you were told to disregard the top bunk. Who told you that?
That would be about Detective Mayo.
Okay. So Detective Mayo, he directed you of which items to look for as far as evidence is that concerned. Is that correct?
That's correct, based on information that he had received.
Okay. And at the time that you processed the scene, were you aware that someone was present on the top bunk during the alleged event?
I believe so. I believe, yes, that we were told that someone had occupied the bed during the time of the event.
Okay. And then you also you viewed of course the panoramic photo in this case, correct? Or the one
PanaScan?
Yes,
Yes,
the
ma'am.
PanaScan. I apologize. And is that a reflection of how the room looked when you arrived?
Yes, when I arrived, I think in the PanaScan we had added evidence markers or placards, and that would have been the only difference from how it looked as to when I had arrived initially.
Okay. And it's your opinion that the room was cluttered except for the floor area?
The room was very messy and cluttered, but there seemed to be just kind of a clearing on the floor when you walked in.
Okay. Did it appear to you that that area had been cleaned?
It looked clean when we were processing it. I mean, it was a little dirty. I was picking up dirt or grime from the floor, but it looked to be clean compared to the rest of the room.
Okay. And that area of the floor, would that be closer to the bed area and the dressers, or would that be closer to the door area?
Kind of in between. There was, I think, 2 desks, and the best area was kind of between those 2 desks and where the tub was that we collected a scraping from.
Okay. Give me just one moment. I have no further questions for you, Ms. Evans.
All right, read it right.
Officer Evans, you testified that you used the alternative light source on many areas of the room. Did you use it on any of the areas inside the closet
No, we did not.
or the ceiling?
No, ma'am.
And did you use the ALS on every square inch of the room?
No, we did not. We tried the best we could to just get an overall view of the room with the light, but again, we were focused on areas that were pertinent or that could have possibly been involved.
Thank you.
Any recross? All right, thank you. Officer Evans, your excuse. Okay, Mr. Robinson, where do we stand?
Your Honor, our witness is here, Your Honor.
Okay, well, ladies and gentlemen, I'm going to have to take up an issue with the attorneys, and so I'm going to need you to step out for a few minutes. All right?
All rise.
Okay. Go on, sir.
Face the clerk or raise your right hand, please.
Do you swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Just have to, sir. Yeah. Okay, with the same.
Your Honor, I guess I would like some basic instruction at this point on where we're going. I know that we had, before the last trial, argued about witnesses and filed memorandums and provided those to the court. Dr. Litton was included in that. His observations and findings were included in that. So technically, as we stand here today, I believe if Your Honor's ruling was that testimony concerning the breath alcohol or blood alcohol content and the effects of alcohol on the human and tissue and blood and the brain would be admissible. And so I guess, to my knowledge, you haven't reversed that ruling, and the state
Well, the state wanted a jury out with regard to Dr. Litton's
okay.
findings and report.
Okay. So
You'll need to examine
We can stipulate the purpose of this hearing, Your Honor, he would be qualified as an expert.
All right, very well.
Is that correct?
Neuropharmacology.
it. Say that again, I didn't quite catch it.
Neuropharmacology.
Neuropharmacology, okay. An expert in neuropharmacology, and that's been stipulated. So we'll move from there.
Dr. Lippman, could you explain your expertise in pharmacology and neuropharmacology and how it's applied, please?
Pharmacology is that field dealing with the effects of drugs. Pharmacologists are
Could
the...
you pull that mic just a little bit closer to you? I'm having trouble hearing.
Pharmacology is that field dealing with the effects of drugs. We are the people in industry who research and develop new drugs. We consult on the drug interactions, therapeutic drugs, poisonings. I should explain the difference between pharmacology and a pharmacological effect, and a toxicological effect is one of dose. All drugs being toxins at a high enough dose. We function in industry, in academia, and in the clinic. Within the larger field of pharmacology, my specialty is in neuropharmacology, which deals with the effects of drugs on nerve, brain, and behavior. And within that division of expertise, I spend much of my time addressing forensic neuropharmacology, which is where the field of neuropharmacology intersects with matters of dispute, arbitration, the law, either criminal or civil, or disability evaluation.
Okay. And were you contacted by my office to provide an expert opinion on Mr. Batey's blood alcohol level over a specific period of time and the influence of his prior drinking history on the blood alcohol content resulting from the amounts of alcohol consumed?
Yes, I was.
Okay. And did you create a report?
I did.
Okay.
This was in 2014.
Okay.
I've since revised it.
All right. Can you explain to the court what, I'm going to have to get a copy, I walked up without, can you tell the court why you revised your prior report?
In anticipation of assisting the court this week, I reviewed the work that I had done in 2014, and I discovered a mathematical error in one of the calculations. It was 5-0 had been transposed from 0-5, and it made a small difference in the numbers. And so I revised the report. In addition, since I had originally written that report, I had been given a report by Dr. Kenneth Ferslew concerning the intoxication of the victim in this case. And in that report, he noted that he had used the Widmark method of calculation in estimating the victim's blood alcohol concentration. I use a more, I would say, modern formulation in my calculations. So in order to compare apples to apples, I also added a Widmark calculation to the work that I had done in 2014, and that was the revision.
Okay. But adding the Widmark method doesn't revise or change any of your findings?
No.
Okay. If we can hand you, is that a copy of your corrected and revised report of April 3rd, 2016?
Yes, it is.
Okay. And what did you use? Okay, let me ask you this. Did you calculate Mr. Batey's blood alcohol content based upon the information you were provided?
Yes. However, I wasn't given all the information I could be provided. And so in order to answer the question as asked, I had to make some assumptions.
Okay.
To be more specific, I do not know to what extent Mr. Batey's alcohol drinking history put him in the category of being perhaps an experienced or alcoholic drinker. And people who regularly imbibe a great deal of alcohol have different kinetics. So for the purpose of these calculations, I calculated it both ways, both as if he was a less experienced and a more experienced alcohol drinker, but I did not calculate it as though he was actually an alcoholic. In addition, I was asked to calculate it for 2 time periods. And because I had 2 different conditions, either a less experienced or more experienced drinker, I had, therefore, a value of blood alcohol concentration for the 2 time periods for the 2 conditions.
Okay.
And then, in addition, I used the other method of calculating.
Okay. And that creates because of that, you create a report with ranges. Is that right?
Yes, those were the variables that I added to the question that I was asked, but even within the information that I was given, there were variables in the data itself concerning the amount of alcohol he had drunk. I could explain that in some detail, but I was told, for instance, that he, as an example, his first drink was at 11:30 p.m. He drank shots of Honey Jack made by Jack Daniels beginning at 11:30 p.m. and continuing for the next 35 minutes. He consumed 8 to 10 single shots of Honey Jack. And those are 2 different doses. One is 8, one is 10. One is bigger than the other. Likewise, he arrived at a party around 2:15 p.m. and drank 3 to 6 single shots of vodka. Again, we have variabilities in the data. It's either 3 or it's 6, or perhaps it's somewhere in between. But for this reason, I had to provide the answer that I was asked for in terms of a low estimate and a high estimate, based on whether the consumption was at the low end or the high end of the reported range.
Okay. And what other information were you provided as to his consumption?
Are you asking to continue the description of the drinks that he drank?
I assume he's not going outside of it before we've got more information too.
No.
I mean, we've got it before we understand. Okay.
Okay.
Let's just
You state in your report the information that was provided to you, correct?
Yes.
Okay, and you also state in your report the assumptions made that I believe you were speaking about, right?
Yes, regarding the dose and also his age and his height and his weight.
All right.
And then the variable that I call apparent volume of distribution and the clearance rate based on alcohol drinking history, either being normal or experienced.
Okay. And did you prepare BAC calculations which are included in your report? I believe it's provided in 2 tables, is that right?
It is.
Okay. And can you explain the normal and experienced BAC calculations that you have concluded, or explain the conclusions in your 2 tables?
Yes. If you would look at the top one, for instance, which uses the average or formula method of calculating blood alcohol concentration, at assuming the low end of the range of doses that were described to me, at 2:30 a.m. his blood alcohol concentration would have been 0.231 if he has normal alcohol kinetics, and 0.216 if he has experienced alcohol kinetics. However, if we allow for the intake being at the high end of the described drinks, it would have been at 2:30 a.m. 0.413 blood alcohol concentration grams percent, or if he is experienced, 0.398.
Okay.
Now, I also calculated, for the benefit of the revision, how those numbers would look using the Widmark formula. And the numbers are slightly different. They are lower. In that, using normal alcohol kinetics, his blood alcohol concentration would have been 0.186 at 2:30 at the low end, or 0.340 at the high end. That is twice the DUI level in the state of Tennessee, up to 4 times the DUI level at the low end. If his experience for alcohol was greater, then he would be clearing it, metabolizing it faster, and so the numbers would be lower. I calculated 0.17 at the low end of the range and 0.32 at the high end of the range.
And that would be at 2:30?
At 2:30.
Under the Widmark formula?
Yes, the numbers are slightly smaller than the all-average formula method.
Okay. And you also calculated his estimated blood alcohol content at 310?
I did. That's what I was asked to do.
And what are those numbers, please, sir?
Assuming normal alcohol kinetics, under the all-formula method, it would be 0.226 at the low dose, and high dose, it would be 0.41. If we assume he's experienced alcohol drinker, it would be between 0.2 and 0.39 at 3:10 in the morning.
Okay. And that, again, is under the average all-formula method.
Yes,
now, what would those estimations be under the Widmark formula?
Somewhat lower, not significantly lower, but whereas, for instance, the value at 3:10 a.m. for the normal alcohol kinetics was 0.226 at the low end of the dose, it is 0.182 at the low end of the dose. And assuming a high dose, it would be 0.34. So the range, if he is normal, would be 0.182 to 0.34, and the range, if he is more experienced as an alcohol drinker, would be 0.16 to 0.32. Again, grams percent.
And are your conclusions offered within a reasonable degree of forensic neuropharmacological certainty?
Yes, they are.
Okay. Can you tell the court about the toxic effects of alcohol? The toxic behavioral effects of alcohol? Yes.
They depend on dose, in that the effects are different at the lower dose from the larger dose. But I think it's more easily understood if one recognizes that alcohol as a drug mimics or facilitates the binding of the neurotransmitter gamma-aminobutyric acid, which is abbreviated usually to GABA, G-A-B-A. GABA is an inhibitory neurotransmitter in the brain. It is widely distributed in the brain. It has an inhibitory effect on the neurons on which the receptor resides. Alcohol facilitates the binding, or the effect, of GABA transmission. So therefore alcohol, acting on the GABA transmission system, damps down activity in the brain areas being acted on, and the sensitivity of the different brain areas varies across the brain, in that the more recently developed areas, such as the frontal lobes, are the most sensitive. As the dose increases, as the drinking continues, alcohol affects more and more primitive areas of the brain, ultimately actually affecting vegetative functions such as breathing. And at that point, of course, one can die. But before it reaches these basal brain areas involved in respiratory control, which are in the medulla of the brain, it first has to influence the frontal lobes, the limbic system of the brain, which is particularly the hippocampus, and then the medulla and the pons, which gives you the spectrum of intensity of intoxication from a light disinhibition that the drug is typically used for instance, in social situations, to the knee-crawling drunk who is amnestic and basically unconscious. In between those two extremes, you have a range of functional deficits in cognitive performance, in reasoning, and in judgment, and in word-finding ability, and in memory and anamnesis, the ability to recall and to lay down memory. So there is a range of effect depending on dose.
Okay. And
the range depends on the brain area being affected by that dose.
okay. What types of change in behavior can the toxic levels of alcohol allow or provoke?
Well, an early effect is disinhibition. It relieves anxiety for the same reason that other GABA agonist drugs do, such as Valium or Xanax. It relieves anxiety and it relieves shyness. By acting on the corticolimbic circuits, the frontocorticolimbic circuits of the brain, it produces disinhibition, where people will do things that they would not ordinarily do. They would be inhibited from doing, and thus they can embarrass themselves by the behavior that they engage in under the influence of alcohol. But there is a neurochemical basis for that, and it is one of the earliest effects of the drug caused by the lower doses. As the doses get higher, judgment becomes even more impaired. Ultimately, when it is acting on the hippocampus, it interferes with the consolidation of memory, so that things which one experiences that would normally be transcribed from short-term into long-term memory, available for review the next day as what we would call memories, that transcription doesn't occur, and so the memory is absent. And it doesn't, when this happens under the influence of either alcohol or a benzodiazepine, it's not because you're having difficulty remembering it, it's because the memory was not laid down in long-term storage. It is not accessible. There are two kinds of amnesia that result from that. One is en bloc and one is fragmentary. But the point that I would make is that when the brain is in that condition, it is suffering from an organic brain syndrome. Memory is not the only thing to be affected at that point. Many functions, many judgments, many capabilities, many mental processes are being impaired at that point, at the point where memories are not being laid down in long-term storage.
Is the professional term for that anterior, and can you help me with that?
I think you're trying to say anterograde amnesia. Yeah, this is distinguished from the amnesia which occurs, for instance, in concussion. If I was to whack someone over the head with a bat, for instance, and they were amnestic for what happened when they were unconscious, the amnesia actually takes out the memory of what happened before that. So you may not remember half an hour before the trauma. That's why it's called retrograde. The concussion deletes prior memories. With anterograde, it proceeds forward in time. So you may remember arriving at the bar and drinking, and that may be your last memory, because the amnesia that it produces is forward in time rather than backward in time like a concussion.
Okay. And can alcohol consumption result in what I'm going to refer to as a blackout?
Oh yes, definitely.
Okay. And what happens to persons suffering from an alcoholic blackout?
Well, though I didn't use the word blackout, I was actually describing that earlier, in that when a person is in such condition that the anterograde amnesia is in process, in other words, they are not going to later remember what they are doing. At that time, alcohol is also disinhibiting them, is affecting their judgment, and is influencing their behavior. And that is the behavior of a person who is in a condition later called, an alcoholic blackout. But they are not unconscious. They are moving, they are talking, they are walking usually, they're not very steadily, and I have seen some videos of that. They are making decisions, perhaps not very good ones, and not certainly with a clear head. But upon later reflection, when asked about that time period, they will have no memory of it. That's why we call it a blackout. In truth, however, they were not unconscious at the time. They were behaving in some drug-addled way.
So
and you can't diagnose that until you know, typically the next day, that the person has amnesia for that period.
Okay. And how long can a alcoholic blackout last?
Several hours. It depends on the dose and the clearance rate.
Okay. All right. Do individuals in a state of alcoholic blackout have an appreciation or understanding for the acts they are committing?
Well, their cognitive function is impaired, so their appreciation is blunted and is likewise impaired, as is their judgment.
Okay. What is chemical submission?
It's a condition that we use to describe the phenomenon that that we have become aware of since the advent of so-called date rape drugs. These are all GABA agonist drugs, and alcohol is one of them, of course. Typically, nowadays, or in the past few years, the word rohypnol, or roofies, was popularized, but back in the 1930s, the Mickey Finn, chloral hydrate, did the same thing. These are GABA agonist drugs that again do the same thing as alcohol. They produce in an individual who is disinhibited a condition, we've called it now chemical submission, where they can be more easily induced to do things that they would not normally do. And of course, in the context of someone who has swallowed a Xanax or become inebriated and then done something inadvisable that they would normally have been inhibited from doing, they are more amenable to suggestion and less likely to resist suggestions in the condition that we call chemical submission.
Because the alcohol suppresses one's ability to have anxiety or shyness?
Yes, and it's also disinhibiting, so that one tends to jump at the opportunity to do something that would ordinarily be considered dangerous or ridiculous.
At either time, 2:30 a.m. or 3:10 a.m., was Mr. Batey's blood alcohol level such that, was it such to possibly create an alcoholic blackout?
Yes, certainly.
Okay. And would Mr. Batey's ability to act in an intentional and knowing fashion at the time of these events be grossly impaired as a result of the alcohol?
Yes, it would.
I believe you have viewed surveillance or video footage from of Mr. Batey in the dormitory. Is that correct?
I viewed all of the security video that I was given, including the victim and Mr. Batey and some people I didn't recognize.
Okay. And working with the effects of drugs, including alcohol, have you had the occasion to know and identify characteristics, physical characteristics of someone who is highly intoxicated?
I had specific training of this in my PhD research, actually, using measuring instruments to assess the degree of discoordination, impairment. So yes, I am familiar with the neurobehavioral deficits caused by alcohol.
And did you identify any neural behavioral deficits in Mr. Batey watching the video?
Yes, he clearly had problems with gait and balance and coordination.
And in your opinion, you identified him as someone on video being highly intoxicated?
Yes, he clearly was unfit to drive, for instance. And he was actually unfit to walk at some point.
And would the video that you observed be consistent with the findings in the calculation tables?
Yes, they're within the range.
Within the range. Okay. That's all I have, Your Honor.
You were brought in this case in 2014, is that correct?
Yes.
And you filed a report November 5th with the court, is that correct? 2014?
Yes.
And that report was inaccurate as far as some findings, is that correct?
There was a calculation error. It was actually a typo error that led to an inaccuracy in the numbers.
Okay, so the
a small inaccuracy.
Numbers in your report were incorrect, is that?
They were not substantially different. They were slightly
incorrect
different.
or not?
They were within the range, and there is no difference in the range. There is no attempt for precision here. There is a range.
But you used the wrong calculations,
No, I didn't. I didn't use the wrong calculation. In the process of a calculation, one of the numbers got transposed. It's quite a complicated calculation.
Okay. Well, why did you revise your report then, if there was no necessary?
Because it was wrong, and it needed to be corrected.
Okay. So the first report was wrong then?
It had an error in the calculation.
And then you filed another report November 21st. That's the first time you mentioned blackouts, is that correct?
I couldn't say that. I don't remember actually what I wrote.
You don't? Okay. But if the report actually shows that's the first time you discussed blackout, that would be the first time you were aware?
No, I think you're incorrect.
Okay.
I have not changed that text. Therefore, okay. It is the same text as previously.
Okay. You say so. So if we didn't get that, then we didn't get your complete report for November 5th, I think.
Would you give me a second to see if I have the earlier report in here? I may not. I don't. I'm sorry.
Okay.
But
so,
I didn't write that text regarding blackouts this year.
Okay.
That I can tell you.
Okay. So if it was in the 21st report, that's when you would have written it, I think.
Pardon?
If it was in November 21st, the second report, that's when you would have written it. If it's not present in the first, you would agree to that, I guess.
Right. I haven't edited it. It's, yes.
Okay. Now, when were you contacted to review this 21st report when you discovered it was an error?
I discovered it was an error last week.
Last week, what day?
Actually, it was Sunday, I think.
Sunday, okay.
I believe it was Sunday.
So you did your revised...
Maybe Saturday.
Saturday or Sunday, the weekend?
Yes.
Okay. And you also added in this new test, right?
In the process of redoing the calculation, I added that that variant of the calculation. Let me explain that it isn't actually different. What I'm calling the all-formula average includes the Widmark calculation within it. All I did to separate out the Widmark calculation was remove that from the all-formula average and put it on its own.
Okay. But you revised your report to show that?
Yes, actually, as I said, because I had been given, since I originally submitted my report, I had been given the report that Dr. Ken Ferslew did for you. Okay. And he used the Widmark calculation. So to enable you to compare apples to apples, I added that form of the calculation.
So when were you given Dr. Ferslow's report?
It came as an email attached. I think it was sometime after it was sometime after, it may have even been the day after, I don't know, but it was sometime after I had submitted my report, as far as I can tell.
Okay. And you realize as an expert that what you put in your reports, what you consider is what you're supposed to testify about, and not add things in later and not supplement your report. You understand it, though?
No, I don't. I frequently supplement reports.
Okay. After the jury's picked, you start supplementing your report?
I don't know anything about a jury. I was told that I would be needed at very short notice.
Okay.
I retrieved the file from 2014.
Okay.
I familiarized myself with what the file was, and I discovered an error in the calculation. In an abundance of prudence, I corrected that, and I sent it at the first opportunity.
But you're not planning to testify about Dr. Ferslow's report or anything about the victim, I take it, since none of that's in your report?
I haven't been asked anything about Dr. Ferslow's calculation or the victim.
Okay. And then you said you looked at videos. When was that?
Within the last 2 hours.
Within the last 2 hours. So after this jury's been sitting here 2 days, you look at videos that aren't in your report.
That's correct.
Okay. And you don't think that's important that the state would know everything you'd considered in making your findings?
I think you should know everything, yes.
Okay. In time for us to prepare, right?
Well, my report doesn't contain any observations from the video because at the time I wrote my report...
You hadn't seen it?
I hadn't seen it.
I understand it.
But in an abundance of caution, just to be completely clear, whilst I was sitting outside, I was given the testimony of the victim to read also. Again, of course, this is after my report.
You understand why the state would get upset if you've given a report that we're relying on is going to be your testimony, and all of a sudden you supplement with all kinds of other information we're not aware of that we can't prepare for. We might even want rebuttal testimony. You understand why that's problematic, don't you?
Yes, I do.
So your initial 2 reports that you said are just basically some small errors in them. Only thing you relied on was information given to you by who?
Dr. Walker and the attorneys. That was my sole source of information.
So did Dr. Walker give you the amounts that he drank to the attorneys?
Both of them did, and I'm not sure that I could distinguish who was the source of which information.
Okay. So there's no real scientific proof of intoxication, you know, blood test, breath test, field sobriety test, none of that?
The field sobriety test is the video. It is abundantly clear.
Okay.
I mean, it's uncontroverted.
The one that you looked at 2 hours ago. Okay. But you relied solely on information provided you by either Dr. Walker or the attorneys, right?
Yes, the specific referral question for me was, can you calculate the blood alcohol concentration of a person who reports drinking these particular drinks at these particular times? And my answer was, you have given me a range, so my answer has to have a range, and I do not know his history, so I have to allow for that also.
And if that information that was given you was inaccurate, then your findings would be inaccurate. Is that correct?
Correct.
Okay. 'Cause garbage in, garbage out, basically, right?
Correct.
Okay. And you had to make several assumptions based on the limited information you were given, right?
Yes.
Okay. One of the assumptions was taking a drink out of a bottle is 1.5 ounces, which I think assumes a shot glass. Is that correct?
No, that had nothing to do with taking a drink out of a bottle. That was, I think, a measured shot glass.
Oh, so you think the proof in this case will show that they were taking measured shot glasses?
No, I was given the volume in shots.
Okay. But shots mean drinking out of a bottle is different than a shot. Wouldn't you agree?
Drinking out of a bottle could be anything.
Could be 1/2 ounce, could be 2 ounces. There's no way to scientifically determine when somebody takes what I call, from where I grew up, a swig, how much it is.
I was not told swig. I was told shot.
Okay.
And I looked up the Tennessee volume of a shot,
Okay.
and it's different, actually, from the Oklahoma volume
Okay.
and the Missouri volume, but it's 1.5 ounces. And I was given the volume of a shot.
And the Wales volume might be 6 or 8 ounces, I guess.
They drink a lot.
Yeah. But my bottom line is, when you issued your report that we relied on, that's the only information you had, was the information about what Mr. Batey had been drinking that night from other individuals, not Mr. Batey.
Correct.
Okay. And you made assumptions based on that. And you talked about blackouts. Have you researched blackouts pretty extensively?
Certainly.
And are you familiar with the Journal of American Academy of Psychiatry and the Law?
Yes.
You consider that a prominent medical journal?
I'm sorry, I didn't hear that.
So do you consider that a prominent medical journal?
Yes.
Okay. And I don't know if you've read this report. It seems to be right on point. Alcoholic blackout for criminally relevant behavior by Dr. Merkelbach, Dick Ravelli, Henry Nyman, Ingrid Mackin-Poppin, and Miss Orsoff. That'd be 2 PhDs, 2 medical doctors, psychiatrists, and a research assistant study they did in 2000. Have you read that study?
I would need to see it.
Okay.
The title doesn't
Sure, I can
doesn't
hand it
really
to
tell
you.
me.
See?
I'm familiar with this, yes.
You are familiar with that? You see the part I marked just on the first page there,
Yes.
where it says, however, claiming an alcohol-induced blackout may also be an attractive strategy for minimizing legal responsibility.
I do.
Okay. And that's pretty prominent in the field, is it not?
It's pretty, what did you
Prominent in your field that
Oh,
malingering as to
malingering,
blackouts.
yes,
In
absolutely.
fact, they say in the United States, the average is 20 to 30% of offenders claim some blackout from alcohol. Is that correct? According to this study.
According to this, yes.
Okay. And they even quote one study that says 80% of sex offenders claim amnesia or alcoholic blackout.
Yes.
Okay. If you would, turn to page 2, down at the bottom. They have it marked there. You see, have I got it marked on page 2 down at the bottom?
Beginning, although alcohol impairs
Right.
short-term memory, which may interfere with storing information about ongoing behavior, remote memory remains intact. Thus, even during a blackout, a person should be perfectly able to retrieve rules of conduct and be aware that what he is about to do is wrong.
Do you agree with that?
Partially. When they refer to remote memory, they're referring to things that we have learned in the past.
Okay.
Yes.
Okay. And you're not trying to testify that Mr. Batey was incapable on that night of forming a mental intent or mens rea under the law.
I'm saying he was impaired.
Okay. In fact, I think you've testified previously in one of my cases that the only way you feel a person could not do an intentional knowing acts if they're unconscious. Do you recall that?
I do. The way that the law in Tennessee is phrased, it seems to be so stringent that you would need to be unconscious in order to meet it.
Okay. That's all the questions I have, Dr.
All right. Thank you, Dr. Lippman. You can step down. Any argument from either side?
I'll wait until I hear.
Well, Your Honor, first of all, obviously what we're upset about is discovery violation. This was not something new they came up with because of severance. This doctor was hired and this report became prominent in the last trial, even though it was not totally accurate. December 1st, they gave his name as an expert, as they were required to do by the court, the final notice day. So they've been aware of this doctor for a long time, so this is nothing new. And then now we come up with, he's reviewed surveillance videos. When we're ready, the only thing he had was information provided by another person that he was relying on. And now we have him coming up critiquing surveillance videos 2 hours before he's getting ready to take the stand. Of course, the state has always argued under Mays and Reed that we do have rights. We have rights to fair trial. A victim has a right to a fair trial, and they continue to be ambushed by experts. And that's exactly what this is. We're reviewing this videotape and reviewing things about the victim's statement, reviewing things right before he goes on the stand. It's just not fair to the state of Tennessee to do this. I mean, here's 703 deals with data lack of trustworthiness, and all we've got is a self-report from somebody to this individual. There's no scientific tests that were done. His previous reports were in error. So under 703, does his testimony lack trustworthiness? And I think it's very clear that it possibly could. Another thing is relevance. Obviously what he's been told is not substantive evidence unless it's testified to in this particular court. I think it will. Obviously the jury has a common knowledge, as Lord Dyer showed, about what alcohol does to you. And he's not testifying about the relevance of the mental state, Mr. Batey. It's not a defense. He's not going to say that because of his alcohol consumption he could not form a knowing intent. It's only relevant as to 3 counts in this particular case, and that's the whole issue. Is this evidence relevant as a defense? And he's not saying even on that. But, so that's why we were asking to exclude his testimony, but we clearly feel that he should not be able to testify about reviewing videos and things of that nature that he does 2 hours before he gets on the stand, and totally surprises the state in this particular case, which has been ambushed before by Dr. Martin, who came in, got his report during jury selection. Here we are after 2 days of a jury trial. The man's considering information that's not in his report, willing to testify about it. So I just think it's clearly unfair to the state of Tennessee.
All right. Mr. Robinson.
Your Honor, I would like to point out that Dr. Lippman's testimony is very consistent with Dr. Walker's, which the state understood and was aware of, and that's who was used in the last trial. Specifically, Dr. Walker did also view videos and commented on the videos, and the comments on the videos are important, and I think that that shouldn't be any surprise to the state, because they see the videos too, just don't want to admit what they really see. Your Honor, we were thrust into a situation with the severance, but I will say this: just like you found last time, this Dr. Lippman's testimony is very relevant, and it is admissible. because it goes as to Mr. Batey's intoxication level. And it's an estimate by using scientific methods by a profound expert on his estimated intoxication level. And it gives ranges. In addition, Your Honor, he is a leading expert on the effects of alcohol and what the effects of alcohol are on a human as it relates to affecting the brain, the body, and tissue. So, Your Honor, I don't think anything's a surprise here to the state, and we think that this is relevant under Rule 703 because it will assist and aid the trier of the fact, which is the jury, on the effects of alcohol on the brain and on the body and the characteristics that can arise and develop from a toxic consumption of alcohol.
All right. Well,
Please, I just say that's what Dr. Walker testified to last trial. It's totally irrelevant. He's not testifying in this case. This expert is testifying. And if these videotapes were so important, surveillance video for him to look at, why didn't he get them in 2014? Why didn't he get them so we would have it in under court so we know what to cross-examine about? A large part of our cross-examination is based on what you didn't see when you formed the opinion. The opinion hasn't changed. You know, he said revised. But, you know, this is just nothing other than just stabbing the state in the back by coming in and start showing an expert right before he takes a stand additional stuff that we have no chance to rebut, no chance to look at what he saw, find out, nothing.
Well,
it's just...
Well, okay, I know you, both of you can go on, but I mean, I'm not going to allow any testimony about any surveillance videos because that's something that's not, his report is not based on that or anything outside of what his report is based on. I will allow him to testify primarily through because of due process. And I think it may assist the triers of fact in understanding this. I think they have a common knowledge of alcohol and what effects it has, but an expert will assist them in understanding it. So I will allow his testimony, but as I said, limited to what he had available to prepare his report. All right? And we could probably allow that about 4 p.m. today. I'll see how the rest of this testimony goes, the rest of the state's testimony goes.
Your Honor, I understand your ruling there. Optimally, Your Honor, he was scheduled to be here on the 14th of next week when we were not severed.
Yes.
Which would...
All right. I'll tell you that. Try it. Yeah, I'm working at cancellation.
You did have the subpoena?
Yeah.
Okay.
You want it?
No.
Okay,
Just
now cancel.
whenever you're finished with it. Just
Okay.
and you're still in the officers.
Huh?
You're still in the
Right,
officers.
right. That's the only one I do. Yeah.
Thank you, Judge.
Nine. Yeah. They ready. We good. So long. What call you?
That was the problem with the appointment. I wanted to have to reboot the appointment, which is our patent trial, which takes care of the video. And if you don't have that,
Gotcha. Okay.
so it's not possible. It's false. And I had an issue with it.
Okay. Okay. Cool.
No.